Great. Well, I think my role is really to try and get John to talk about his book, which I'll try and do. As will become apparent from my questions, I'm actually the wrong person entirely to be doing this, I think. But we will find out whether that's true as we go along. So I think probably the best place to start, as with all good books, is with the title, From Personal Life to Private Law, which I think reflects probably the central claim of the book, which might be termed the Monist thesis. So, a page 8 of the book, you say that private law would have us do is best understood by reflecting on what we should be doing quite apart from private law. So that this is as it were, a new continuity thesis, as is a different continuity thesis, that there's a continuity between the reasons we have for behaving in the world and private law. Have I grasped the central claim?
You sure have. That's a perfect encapsulation, yes. Do you want me to explain it some more, or
well, so
you ask me a question?
So basically the target then becomes the Kantians, doesn't it? So in the people who have gone around saying that there's this sharp divide between virtue and duties of right are the Kantians. So if you're a utilitarian, in a sense, you're not going to have too much problem with your central claim, because utilitarians are monists in that sense too. They think it's all just, in fact, they're even more monist than you are, in the sense there's sort of ultra monists. There's a sort of, it's all about the util. You know, there's this one big thing which we're all aiming at, but everything is like that. But you're not a utilitarian and you're not a Kantian, so in what sense are you a monist?
Okay, so that's a very good place to start, isn't it? Because I drew attention when I used the word monist to the risk that it was going to be misinterpreted, because it's often used in philosophical writings to describe positions like the classical utilitarian one, which believe in only one value, right? So only one thing is good for a classical utilitarian, and as you say, it's a util. That in turn there's lots of other interpretations of what a util is. So I'm not that kind of monist. I'm not a value monist. The book is all about the interplay of lots of different kinds of values. The kind of monist I am is consistent with being a value pluralist, with thinking lots of things matter. And that means that one of my enemies in the book is the economic analysis of tort law. Depends which side you come from, whether you think I'm more against them or more against the others. But I try to even-handedly wallop all of them. And that's because although I'm a value pluralist, which sets me against the economists, I'm a monist in this way, that I think that there's no fundamental divide between public reason and the rest of reason. Yeah. So there's a whole tradition of thinking public reason is special, different. It has to be adapted to accommodate the fact of disagreement or the fact of autonomy or some other fact that impedes the public endorsement of the values and therefore the reasons that animate us in everyday life. And I'm against that, as you say, divide, which says that once we move from personal life into law, politics, and so we cross into a different world, and all that stuff has been left on one side in favor of new stuff.
Yep.
So that's the sense in which it's monist, and the expression monist is Liam Murphy's choice for that. I really wish he hadn't chosen it because of the risk that it would be mistaken for the other kind of monism, which I'm against.
Yeah. Now, there's a sense then in which why I'm the wrong person feeds into what you've just said, which is to say that you also make claims about what, as it were, philosophy can do for law or for lawyers. So, like Tony Blair, I'm a sort of pretty straight kind of guy. I do doctrine, right? And so as a sort of doctrine guy, what I want philosophy to go and do is say, well, whether or not this case here is right or wrong, is this dissent the right one, or is it the majority actually win?
Philosopher who wants
right. So in a sense, the temptation of some of the economists and the Kantians and so on is that they hold out for people like me, this snake oil and your view of the world, right, which is this snake oil, which is they purport to be able to answer these sorts of questions for us. Whereas as a value pluralist, in a way, in a sense, you're going to say to me, that's, as you were, to basically misunderstand my own subject, in the sense that what law is for is to, settle with rules some of the incommensurable questions that all the value pluralism gives rise to, and that they're appealing to some grand theory to then tell me whether or not this dissent is right or this case is wrong or whatever is hopelessly misguided.
Yes, I mean, I think good point.
Yeah.
Right. Hopelessly misguided. I mean, there are lots of different things going on there. So one is a matter of philosophical temperament, right? So a lot of people who work in applied philosophy, of which you might think this is an example, tend to think the job of the philosopher is to deal with things that are controversial and to show which way you should go in the controversy. And I tend to think the job of the philosopher is to show that the really obvious things are not that obvious. Right? So I don't tend to take an interest in the topics that are always at the front line of public debate, or, I couldn't tell you as a philosopher whether Brexit is right or wrong. That's a different sort of problem, right? But I do know how to see structural complications that are not visible to the naked eye. Why have a philosopher unless they can do that for you? So what I tend to do is I tend to take the stuff that's common ground and to see how it's organized. So that's a temperamental thing, or a view about what philosophy could contribute. And it leads me naturally to hold some of the more concrete views that I hold, like that there's a reason why we need lawyers, which is to solve some of these controversies by authority. In many of these cases where their temperature rises and they shout at each other, there's not one ideal way to go. Yeah. There's a lot of stuff going on, and it would be good if we could reach some provisional détente, and sometimes the law can do that for us. And so I tend to think, well, I'll hand over to the lawyers when we get to the controversial points and see what they can achieve, see if they can get some sort of working modus operandi for resolving cases. That's so if you think that there's anything in this book which casts a dim view or casts a dark light on doctrinal lawyers.
No.
You could not be further from the truth.
No, exactly.
And this is
wrong. No, of course not.
This is in praise
of
black letter lawyers.
In a sense,
what they do.
We've misunderstood the value of what we do.
Exactly. Because if philosophers could tell you how to decide the case, why have lawyers?
We've misunderstood our very job. Now, I did say to you I was going to take the book in chronological order, so I'm not going to quite do that. No. Because reading the book, you're temperamentally, I think one of the nice phrases you've usually got is about not being a splitter or a lumper, not being a hedgehog or a fox. Every idea is going to have its right size and so on. But there is, at least to my reading, one very large sort of ground norm uber claim about what law is for, which appears around page 76, 77 of the book. Now, I'm putting my cards on the table. My view is if you accept this grand claim about what law is for, then everything else follows. It's irresistible if you accept the grand claim. And somebody said to me that what the grand claim is based upon the fact that you're a reasons fundamentalist, which strikes me as worse things to be than that, I guess. Which is to say that the point about law exists to improve people's conformity with reasons that already apply to them, including but not limited to reasons to act. You put it slightly differently higher up. The law exists to improve how people, including its own officials, will act. So if you accept those propositions about what law is for, then in a sense, inevitably, your monist view goes through, because once you've accepted that view about what law is for, then inevitably the two are just joined at the hip, and our good reasons for action must be what law is essentially all about because of that first initial big proposition. Am I mischaracterising?
No, not at all. And I think that's fair enough. This is actually just a restatement of the monist position that I announce at the beginning of the book. It's the place where it becomes most important to the argument, but not all important to the argument. There's other things going on as well. But yes, I think it's fair, and I don't think that you should regard the book as perched on the tiny foundation of this so much as an illustration of how it goes through.
Right.
So if you hold the view that I hold on that point, then a lot of the other things that are in the book will seem natural to you, and if you think the other things that are going on in the book are attractive, then this should lead you in turn to be more tempted by this, as you think, fundamental presupposition.
Yeah. So now the supposition, in a sense, you're quite upfront in some of the sort of slightly surprising conclusions that initially gets you to. So you then say, well, I've got a good reason to ring up my elderly mother at the weekend. Well, without more ado, that provides the law with a good reason for saying, well, we've got to try and make you comply with that duty to ring up your mum. Or you could go further, I guess, and say, well, I've got good reasons to clean my teeth, and and do all sorts of other things which civilized people do. Well, without more ado, on its face, we've crossed the threshold now, and the law is in. The law is in to say, okay, law is in the business of trying to induce people to comply with their good reasons for action, subject to. And then a large number of sort of caveats come in as to why it might be going too far. Am I mischaracterizing?
Yes, that's right. But I mean, I think when the way you put it is slightly tendentious in the sense that I'm not quite sure that I would say without further ado.
Yeah,
I would say all else being equal.
Sure. Yeah.
And of course, all else is never equal, especially with the law. The law is, a clunky thing, and very often the law would have you jump. The amount of jumping will go down and not up. We think about the counterproductivity of many whole legal regimes, and they're driven by a kind of, I think, irrational moralism.
Yeah.
Like the persistent belief that we should come down on the drugs trade like a ton of bricks, even though that makes the drugs trade maximally profitable. Yeah, and so in that sense, drives yet more drugs trade. That's irrational on the part of the law. It's sort of a form of legal moralism that I'm dead against. Yeah, contrasting the form of legal moralism that I'm dead in favor of.
Yeah,
which is that if it would be the case that there were no costs in other ways to getting you to brush your teeth by regulating the brushing of your teeth,
yeah,
I would obviously be in favor of it.
Yeah,
just there are all those costs. Leaving aside the fact it's not going to work, there are additional costs as well, as you said.
But then from this proposition about what law is for, and the proposition about the Monist thesis, it strikes me that this thesis isn't really specific to private law. That it's true going to be true on your view of law in general.
Yeah.
So that this is not really a private law specific claim. It's a claim about the continuity between law in general and our personal life.
I think that's fair enough. Yeah, and I think that probably you could say that that the choice of subject matter is driven by the fact that this is a more novel or idiosyncratic view among private lawyers than it is in some other parts of the law.
Right. So in a sense, this is how this principle plays out in this field. Is really the
and that's of course a big theme of the book.
Yeah.
What should we regulate and what should we do about violation are intimately connected problems. But yes, even if you leave that point on one side, I'm not sure that you've yet driven the wedge that you're imagining could be driven between the law and other parts of human experience. Right? So imagine your relations with your friends and the possible questions that arise when you try to get your friends to be better in various ways. And obviously you have more subtle techniques at your disposal most of the time. If you're a good friend, you can give advice, and the law's not very good at that. You have to go to a lawyer for advice. The law's just going to go straight to techniques of enforcement. But still, the questions are the same. Given that it's not your action, and the question arises, what can you do to contribute to it? And so I was assuming that was a pervasive problem in ethics. But I was tending to think, because of work I'd done before on problems about complicity, that this was the most difficult question in ethics. Right? The most difficult question in ethics is not what should I do, but how should I contribute to what should be done? Right? And so the whole problem about life is really not reasons for me, but reasons for others and what my part could be. And what difference is it going to make in the grand scheme of things?
Sure.
What I do when other people are doing all sorts of wrong things, what can I do about that? And if the answer was always, well, I should mind my own business, that would be very disappointing, right? So there must be some things that should interest me about other people's behavior. And you might think, well, the law is just some of that stuff writ large and made clumsy. Writ large is good, made clumsy is bad. It's a shame that the only way we can write it large is by doing something that's going to create all sorts of tragedy and suffering, by locking people up or causing them to lose their livelihoods. So, but we're sort of, the more ambitious we get in our thinking about how we could contribute to other people's successful lives, also the more dangerous we get. And so we're in a tragic situation where the more we are tempted to do, the less desirable it is to let us do it. And the rule of law is an ideal which is meant to contain our over-enthusiasm for getting people to do things. Because, if we don't have the rule of law, our enthusiasm can lead to gulags and, techniques of brain manipulation like Orwell and so on. And the rule of law is supposed to put a bit of a damper on the extent to which we're willing to go to what would be outlandish extremes to get people to do the right thing. And the law is itself full of dangers, but not dangers as bad as that. But it's part of the story of the book is about how private law is one of the difficult and precarious tracks you might follow to keep the law's tendency to be overweening and oppressive in bounds by distributing power outside the officialdom into the hands of litigants. So that's the last chapter becomes dominated by those themes.
I think we've made it to chapter 1, which is good.
Oh, and chapter 6.
Well, we did yes. Bit of recourse at the end there. But chapter 1 is, now of course, somebody like me is going to say, well, this is all about rights. But of course, you're very careful. So I'm not going to use that word. That's swearing. That comes in right at the end. That comes in right at the end of chapter 1. So what you say, the chapter Something Comes Between Us is about how, what it is for a duty to be owed to another person. How do we identify those duties which are owed to another? Because obviously some duties aren't owed to other people. So my duty to clean my teeth, well, maybe. Well, even that's difficult. Right? I've got children and so on, if my teeth drop out. But, parking on double yellow lines, whatever. But it's about the identification of how we work out whether a duty is owed to another, how it can be relational, and in what senses it can be relational. And you give it, I think, very helpfully, a very powerful definition of that, where you say one's duty is a situation where a duty is another person figures in the reason for one's duty. So if another person figures in the reason for one's duty. So that a nice illustration of what you mean by that is, I'm going to foul up the example now because I don't remember it is. I agree with my mum that I will make a gift to my brother. And my mum figures in my reasons for action, and so my duty is owed to her, even though the beneficiary of what's going to happen, the person who, as it were, has the, in inverted commas, interest, in inverted commas, in what's going to happen, is going to be my brother, because he's going to get the benefit of this. Because she forms part of the reasons for my action, the duty is owed to her. And this has strong echoes of, and you'll correct me if I'm wrong, there's strong echoes of, but is a clarification or a refinement of what some people used to call the sort of interest theory of rights. So that it looks very similar to that, although you're clarifying it. So, well, that's not quite right, because sometimes you may not have a personal interest in the performance of the duty, but you may form part of the reasons for that duty, in which case the duty is owed to you, even though you yourself may not have any interest in its performance. Am I along the right line?
Yes, I think it's that example is really troubling, isn't it? So I follow it a certain distance, and I say, let's move away from those really complicated examples where you've got promises and undertakings, where the reason for honouring the promise or undertaking is owed to one person, but the benefit of the content of the promise or undertaking goes to somebody else. There are reasons for avoiding that, because if I were to carry on with that example, I get sucked into the big problem about the rationality of promise keeping,
Sure, yeah.
which I didn't want to make the main theme
Yeah.
of the chapter. So some people say, just to get that point straight, that there's a merely promissory consideration, that being the beneficiary of a promise, never mind the content of the promise, is sufficient to get the promise going, to make it binding. And I say, no, there's a dependency on the content of the promise at some level. Yeah. So I didn't want to have to decide that question. So I didn't get into third-party contracts. Yeah, you can see why not. Yeah, that's right. So I was just leaving the proposition, as you read it out, a bit more abstract and trying to concentrate on simpler cases. And yes, you're right that it's the same. Fundamentally, it's the same set of instincts that led Neil McCormack to formulate what he called the interest theory of rights. Sure. Back in the 70s, that was came to be contrasted with something called the will theory. Yes, my reasons for not constantly banging on about the interest theory of rights were mainly that you don't want to bang on about something that's already got a lot of baggage. Sure, You know, so if I say, well, this is a defense of the interest theory of rights, it's not long before Matt Kramer says that I've got the interest theory of rights wrong because you know, you can imagine what happens next, and there's a big distraction. So instead, what I did was I postponed the stuff about rights.
Yeah.
I thought, well, let's think about the duties,
yeah,
and how they come to exist, and what it means to represent them as relational. I had this strongly relational idea, and then later I had a more weakly relational idea. And let's just keep rights talk out of it to avoid all that. And then at the end, I sort of said, well, yeah, you could have done it with rights, but it wasn't needed. Yeah. Yeah.
But in a way, if for you personally, in a sense, this is quite interesting, right? Because often in your work, you've said, well, Hart's misphrased something. You know, Marx said what he really meant. It's quite, but it's quite rare for you to say he got something wrong, flat wrong.
Yeah.
Yeah. And this is an occasion where you end up saying he's got this flat wrong. Yeah. So you get to the end of the book, you get, do you want the references 203, 204 at the end? Yeah. We get Hart in his choice theory, where Hart seems to say, well, the directional, but the way for determining to whom the duty is owed is who has control over the duty, he says. That's the way which we work out to whom the duty is owed. Who it is who's got the control over it. And that's the key. And then you reject that. So no, he's making a category error, a fundamental mistake. That's all wrong. So this is quite a bold stage for you in your life, in the sense you've got hard getting something flat wrong rather than
very hard to get up to now. Yes, possibly.
Right.
Yes, maybe. I mean, I've always thought that he overstated a good point.
Yeah.
And you can see that he's overstating it sort of on the face of the record a bit, because he said that this was only true of legal rights and that rights in other domains weren't like this. And it really makes me a bit suspicious, you know. And now, admittedly, that's not the only time he makes that move, but this is a particularly damaging use of that move.
Yeah.
It meant that rights discourse was really quite dramatically different in the law. And so it's prima facie a reason to reflect on whether he got it right. And I tend to think that once you delve a bit deeper into it, you can see that he was on to this much, that very often the law does associate being the beneficiary of a right, being the person to whom a duty is owed, with being the person who has the power over something. Now, it's something different in lots of things. Sometimes it's over the performance. Sometimes it's over the existence. Sometimes it's over the enforcement. Lots of different things could be controlled, and there's a certain amount of variety, even in the law, about which levers the beneficiary gets to pull. So all of that I thought was insightful, but to turn it into an analytic truth about legal rights seemed to me to be a step too far. It's just a common feature of many legal rights. And the important thing to do is to understand why the law might want to add that feature. Right? So chapter 6, to jump right to the end again, is all about what would be good arguments for the law to often, but not always, add that feature, so that you're not just the beneficiary of the duty, but also the holder of the power over something. And so I give a few sorts of considerations that bear on that towards the end of the book. But in the process, you have to treat them as logically independent. And if you embraced Hart's account of what legal rights are, you would end up not being able to discuss them as relatively independent problems. And then you wouldn't be able to get to the point of understanding why they are so often brought together. Why the beneficiary of the duty is also often the controller of something else.
Yes. Now, I confess, why I'm leading you down this path, I confess the reason I'm leading you down this path is I think Hart's right.
Yes, I knew you thought that.
And that there's actually no conflict between Hart's usage and the way you want to use it. These things aren't in tension with one another in the way that's commonly supposed. They're just different usages. And that Hart's usage is a lawyer's usage, actually, in my view.
Yeah.
And you're using a moralist's usage, being implied, if that's, but the reason I say that is that, say, the law posits that you owe a duty to do something, so there's some statute saying Gardner must do X, and then we have to work out who, if anybody, is the right holder at the other end. Who is this duty owed to? Can we play your game of saying, well, we appeal to the reasons for the duty in working that out? Because in a sense, when we're in the law world, the positive law world, one and only sufficient and necessary condition for the duty's existence, the only reason in play, is it's been posited by a position of person of authority. That's it.
Yeah, good.
So that how are you going to go around working out?
Excellent.
I mean, do we go around asking the legislators, well, why is it you did this, or isn't it, as it were, the real answer, Hart's formal one? The answer of who's got the right is who it is. The law is now posited has got the control.
So that's a clever little pencil movement on a legal positivist like me.
Yeah.
Saying, well, why, suddenly
I
you
like
think that
it.
the reasons are all these other things like truth, beauty, and religion. And before you always thought it was just what
I mean, there could be terrible
Parliament
reasons.
said.
could be terrible reasons or no reasons
right.
or irrational reasons, but just as long as they posited this person.
No, that's right. So just to get clear how these things are connected, how you could be a legal positivist and think all these other things that I think. The obvious way you could think it is like this. You could say, well, there are the reasons why you have the duties you have, and then there are the supposed reasons why you have the duties that you have. And when we're in the law, we're very often interested in the supposed reasons. The judges have to work with the supposed reasons. They don't usually just say, well, just because Parliament said so. They say, well, Parliament said so with the following things in mind, or trying to deal with the following problem, or realizing that there was a weakness in the law here that needed to be reformed. See Law Com 132. Yeah. So although the courts are admittedly reluctant to interpret statutes by going too far back in the literature, they're not reluctant to give rationales to legal rules, even legislative legal rules. So they're already in this business, of connecting up the positive law with the set of possible reasons for having it. And even when they don't use it to interpret the law, they use it in lots of other ways that this book is about, like how to work out what would be good compensation or what would be good specific performance. They're thinking about what must have been behind the law, such that now we can remedy the violations. So all of that's going on, and I'm not really being very radical, even among legal positivists, in saying all of that's going on. I'm just saying it's important in lots of ways. And one of the ways in which it's important is that in order to understand what rights people have, you have to think about why they would have them. And I don't think it's quite true that the law will say, oh, no, we never talk about that.
No, of course not.
We'll just look at who's going to be in charge, or who's going to be in control. So think, as I was used to thinking in a previous part of my working life about the criminal law context, it's true that the Crown Prosecution Service gets to decide who gets prosecuted in the criminal courts. Either it gets to initiate the proceedings or to take them over. It's a great power, but it's not the Crown Prosecution Service's rights that are violated when people are murdered or raped or burgled, right? People's rights are violated. And you might say, well, why? They're not getting control of the proceedings. And you're like, well, in private law they might, but in criminal law they don't. all sorts of good reasons for that. But it doesn't mean it wasn't their rights. Yeah? And the reason why it's their rights is because, well, to put it crudely, they were the people most affected. And somebody who says, as some contemporary writings do say, that murder is a crime against us all, are being massively exaggerated in there. Wait a minute. Think about the person who was murdered and their nearest and dearest. We'll get to all of us soon. But right now, that's where the action is. I think we've got to be careful not to become too bold in claiming that criminal law is all about all of us. It's also about each of us.
Yeah.
And private law adds something and sometimes substitutes. And the interesting question is, one of the interesting questions is, why use one technique or the other, or sometimes both?
Yeah.
Why make some things crimes but not torts, some things torts but not crimes, and some things crimes and torts?
Yeah. So to go back to this question, so things I shouldn't give the impression, or we shouldn't give the impression of, is that this is a very dry book, in the sense that one of the nice features of the book is that you start off with lots of examples from, I don't know, popular culture or Jane Austen or wherever it may be. There's a magpie grabbing these examples from all over the place. But the very first example you give on page 1, I think is a bit, for me at least, problematic.
Yes.
And this is the example from an advert for Wilbur Smith, a Wilbur Smith book called Predator, which I suspect you've not read.
Not really. Sorry.
And so the advert...
It's the only book in there that I discussed that I haven't read.
Very poor research, right? So the puff for this Wilbur Smith monstrosity, which you...
I didn't say it was a monstrosity.
You start the book off with is, I can't do the accent. They murdered his wife. They destroyed his future. Now they have to pay, is the puff for this book. So they murdered his wife, they destroyed his future, now they have to pay. And then on the page, you use this and you say, well, what is alleged on behalf of the claimant is a wrong against him. They murdered his wife. A loss to him associated with it. They destroyed his future. Now, in a way, if you take your views on directional duties, that's right. You would say, well, if I'm about to kill someone, shoot them dead, who have I got to take into account in whether or not I kill them? Well, it's all their loved ones and so on who are going to be adversely affected. So the person you've got to mainly take into account if you kill me is my indolent son, who's going to be the main person prejudiced by my death. It's him you've got to be taking into account. And so you then think, well, it's these people who you're supposed to be taking into account who have been the victims. You can then say, well, I'm the victim of the wrong. I can sue for damages. Now, of course, that just isn't true as a matter of the positive law anywhere.
Right.
In this example, right? So in this example, it isn't the case that any husband can't sue for the murder of his wife in England, nor anywhere else in the common law world, nor in any civilian jurisdiction I know of. What you could do in England is you could say, I'm a dependent of my wife. She has been wronged. I can sue for the fact that I'm worse off as a result of the wrong done to her. Pay me damages. But it's not the law anywhere that you can do the game of saying, I have been wronged because my wife has been killed. Now, as a matter of morality, you have been wronged, but there's no legal system anywhere which says you've been wronged by your wife being killed. Now somebody like me, because I'm going to follow the heart line, I'm going to say, well, the reason for that in law is you've got to ask who the right holder is here, and who is it who holds the right not to be killed or injured or so on. Well, it's the wife, because she's the one who's able to say, okay, you can punch me on the nose, you can run me over. Even, I think, in private law, you can shoot me in the head. And then there's no wrong done to her. The husband has no such control. He can't say, yeah, go run her over. I'm sick of her. And that shows that he's not the right holder here. She is. Yeah. And this isn't really to do with enforceability either, because if it was enforceability, the estate could say, pay damages, but pay the damages which are owed to the husband. You owe money to the husband. I've got standing to sue and make them pay that. But the estate can't do that either. There's no obligation in law enforceable or unenforceable or otherwise, owed to the husband. And so the Hartian in me is going to say, well, the reason for that is it's only the wife who's the right holder here, not the husband.
I think you're expecting too much of Wilbur Smith's.
Really.
I mean, so the point of beginning with Wilbur Smith was not to make any claims about what the law would allow or not allow in this case, but just to show the interesting ways in which our language of revenge and the thrilling stories of Death Wish and James Bond and so on are all interestingly tangled up with the boring old language of pleadings and statements of claim. And so to raise the question of what's the direction of travel between these two topics. So should you think that private law is a sort of dry, boring rendition of a great revenge tragedy, or should you think that revenge tragedy is a massively exciting development of ideas that are most at home, fundamentally, in private law? So I went for the second one. I said, dry as it seems by comparison, Wilbur Smith is piggybacking his conceptual apparatus, or his publicists are, because as I said, I didn't read the book, but that's what it said on the poster. His publicists are piggybacking their sort of excitement on an apparatus of, suits for bereavement damages or stuff like that. And I even add another line a little bit later to the publicity and say, because there's something missed out, which is he's the one who gets to exact this. So that's the control feature coming back.
Really isn't.
No, well, that's right. I'm sorry. I'm a lawyer, but I'm not that much of a lawyer.
Right. Let me give you some. What would the Kantians say to you? So we've got Ripstein and Wine and these crowds say to you. So a couple of moves they usually make against this a continuity type thesis aren't available against you. So common moves are things like the fact that the standard of care in tort law is objective. So they're sort of their view that say that observably the fact that in tort law we have a sort of Nettleship and Weston objective standard, and we make no account for the fact that you are incompetent, you can't reach that standard, you can't make that standard so that you're not morally to blame. But that sort of move is not open as against you because of your views about what you mean by morality, in the sense that even the person who can't meet that standard has good reason to comply.
Exactly. I'm giving these guys a hard time by thinking that that's true in private life as well.
Right.
Nettleship and Weston would be a good decision for your friends or your partner to make.
Exactly. So in the sense that you've got to see how your views on as it were, both private law and morality meld together, right? So they're diverging from the Kantians at both ends, as it were. But another move they might make, which you don't really discuss that much in the book, which I'm interested in your views on, is the positive duties of assistance. So that somebody like Weinrib and Ripstein is going to say, this is our trump card. Gardner, they're going to say, this we've got you on this. They're going to say that there is no positive duties to assist in law, nor should there be. And let me give you an unpleasant example. Now, one of the points you make in the book is you don't like the sort of philosophers' games stories, but I'm going to give you one anyway, and it's about because
we have to do it now.
Which is the sort of the unpleasant one is the Judith Jarvis Thompson abortion one, which is a classic, in my opinion, Kantian example. So we all know this example where you wake up and you've been hooked up
to the
violinist, and you know that if you unhook yourself, the most brilliant violinist in the world is going to die, and what's being required of you is that you stay hooked up for 9 months to keep them alive. Like 9 months will let you off, then you get out, but it's 9 months to keep this brilliant alive.
I think after that, actually, you've got to pay for their education.
It's
not as quick and easy.
You're telling me. I'm just away now. Right, but
a little reverie there.
But the reason I said that's a sort of classic Kantian move is the point about that story, in a sense, is how would you behave as a good person, right? So what would I say as a good person you should do in that situation? Well, I think as a good person you should stay hooked up. Now, I think good people say, okay, I'm going to sacrifice myself because there's this great violinist who I do not want to die, and I'm going to just go through it. And then the point is to say, well, the violinist has no right that you behave like that. That might be virtuous thing to do, but there's no right that you come to the assistance of the violinist. Yeah, but that move doesn't seem to me to be open to you because of your views on reasons. In a sense, the continuity says, well,
is it open to me? So look, so forget the law for a minute and think about how we think about ethics. I think even outside the law, we would say that it's a sign of your excellence that you're willing to sacrifice yourself. I actually think sometimes it's not a sign of your excellence. Sometimes it's like a crazy, stupid thing to do. But sometimes it's a sign of your excellence. But we often still say, and one of the reasons why it's a sign of your excellence is it's so far beyond the call of duty, right? Yeah. And that's true morally as well. It's not just the law. Yeah. Right? That's a way of thinking about ordinary private ethics as well. You see, you give exceptional recognition and gratitude to people whose behaviour is beyond the call of duty. Yeah. And that doesn't seem to be just because, or even because, we've moved into the questions about law. That's still in the world of, the good and the true and the beautiful, that distinction. And so there is an interesting question, which I don't discuss in this book. Obviously, it would take up a lot of space, which is how it's possible for there to be supererogatory actions beyond the call of duty in ethics. It's a big, difficult question. And I don't go into it, but of course I think that there can be. And I'm kind of assuming that. And I'm assuming against the Kantians that it's not the question of which actions are your duty and which actions are beyond the call of your duty doesn't just arise when you're a legislator. It arises everywhere.
So the move in the violinist case then that you're making, if I'm right, is that it's supererogatory behaviour to stay.
Well, it might even be crazy behaviour, but assuming it's not crazy, it's supererogatory.
Supererogatory. Yeah. So okay, so let's make it less onerous then. So we'll go back to some more of the more standard tort examples then, which is the baby drowning in the inch of water, and you're walking on by, and on its face, private law as it stands says, walk on by, no problem, we're not going to, and then so the Kantians can say, got you, in the sense that they're going to say the reason for that is because the duties we've got as a matter of right are grounded in something like independence or something like that, and that although that imposes duties on us not to drown babies, not to smash up other people's stuff and not to defame them, there's no duty imposed to go and pick up babies even when it's easy, or repair other people's bicycles, or speak well of people, even when it's easy for us to do, even when good people would do these things. So what are we going to do with those ones? It's hard to say that's supererogatory.
No, I totally agree. That's good. So some of these problems are discussed in the book in chapter 5, where I try to understand how it can be that our interest in value isn't always totally impersonal, that we can have special relationships with value that are ours, that differ from the relationships that others have. And what would explain that? Because you might think, if you're going to take my sort of the brickwork of my moral thought, that all you've got are reasons, and they're all impersonal, right? It's good that babies should not die, or that violinists should get their chance, and so on, and that this should just be even-handedly of concern to all of us. And obviously, I don't think that.
Yeah.
And so quite a lot of chapter 5 is devoted, albeit I think rather cursorily, to trying to establish how there could be a role for special things that are ours, that differ from the things that are other people's. And in the process, I also talk about an important distinction, which doesn't map onto the distinction you're drawing, but which concerns the difference between respecting value and not maximizing it. And so there is some discussions there. It doesn't quite get to the case you had in mind, though. So I think that when we get to the case that you have in mind, this is where I start to think that Guido Calabrese is onto something. I mean, you do have to think about what the law could reasonably expect to achieve by highly interventionist regulation of what the Kantians would call our private duties. And there's some well-worn disagreements about that, and I was sort of not discussing them, but imagining them going on. So if you make it the case that you become a tortfeasor because you walk past somebody drowning in a canal, then you're not going to go to canals so often. The effect is going to be that fewer people are going to be rescued from canals. So that was immediately counterproductive. This seems to me to be the natural way to think about the law's reluctance to create legal duties in situations where we rely on people to respond to emergencies, things like that. It's going to add to the existing incentives not to get yourself into those situations. So I like the economists sometimes. Yeah. I think they've got some crazy ideas about what matters in life, but they haven't got totally crazy ideas about how we should approach what matters in life. Right? They've got some pretty good ideas about that, which is we shouldn't be counterproductive in approaching those things. And if we're about to set up a rule that's going to make it the case that more people will drown in canals, something's gone wrong.
Yeah. Now, how are we doing for time? So I need to try and get you through the rest of the book.
Yes,
about 15 minutes.
We're going to have to come back next
week. I think we should just carry on all night. I personally. Chapter 2. I thought to.
Well, we've done 5 and 6 as well.
Have we? Oh. Chapter 2. So chapter 2, in a sense, is if you look at it from my sort of view of the world, in a sense, it's more at the morality side of the divide for me than the law side, in the sense that what we get in chapter 2 is in a sense a sort of tripartite discussion between Tony Honore, Ripstein and yourself, if you're siding with Honore.
Yeah.
And well, correct me if I'm mischaracterising the chapter. So one of the sort of Kantian moves is to say, well, or one of the problems with the Kantians in a sense, is to say that in morality, what matters is the intentions with which you act. To be virtuous is to intend to act well, and then if things happen to go badly, but your intentions were pure, your mind is pure, you're not blameworthy in a sense. And then if you take that view, very difficult to see why as a matter of morality consequences matter at all.
Yes, or outcomes, I think.
Outcomes.
Yes, was Honore's word, yeah.
Why aren't we just looking in the head and saying, well, isn't that all that morality is about? And then you get this whole problem of moral luck which arises. And in a sense, chapter 2, the point of chapter 2 is that your view is, well, that's just not a problem. This is a sort of non-problem in the sense that what we are responsible for is what we've done, not what we've intended. And so our responsibilities are not controlled by what goes on in our heads, but our responsibilities are what we have done. What we are is what we have done. That is us, in a sense. And so that chapter for me seemed to me to be really a chapter about, you could put the morality and the laws together. That's the morality side of the thesis, showing you why it is. The morality is not pulling away from the law in this regard.
That's right. So I think you could say that
mattering.
So the sort of master mistake might be to think that morality is the same as virtue. Yeah. I was a bit worried you were heading that way before as well with the violinist. But there are lots of problems in morality that are not problems about virtue. And people who are morally upstanding are, among other things, virtuous, but they're not morally upstanding. It's not that their virtue is independent of the evaluation of their actions. Right? Their virtue is an implication of the evaluation of their actions. And there's luck in virtue as well. Only the extremely rich can be extremely magnanimous. That was Aristotle's example. There's various ways in which the rest of morality and the part that's concerned with virtue interact. So I wasn't really thinking about virtue. In fact, virtue doesn't come into the book very much at all. I was thinking about the rest, about how we're implicated in what we do, how we have to explain ourselves when we do it, whether it would be possible to imagine a world in which all we had to explain was what we willed. So Tony Honore, whose tie this is, by the way, I saw Tony this morning. Please wear my tie because I can't come. So I put it on. So he made this very influential argument. He wasn't the first to make it, but he was certainly the most impactful person to make it. He should get the prize for the ref, for having had the biggest impact. And he said that you can't see the world that way. You can't think of what you decide to do or try to do or will to do as a sort of problem without evaluating what you do. Right? What you do has got to be the main topic, and the rest is then just in the sort of pulled along behind it. We're interested in what you try to do because you should try to do what you should do. That's the Honore line of argument, or at least that's how I interpret it. And so it's meant to, you're right, it's meant to be a point about practical life in general.
Yeah.
And it holds in morality. Yes, it's a point about life outside the law, which gives a more fundamental explanation than some people will give of why it's like that in the law as well.
Now we're nearly there.
Okay.
Chapter 3. Now, chapter 3 seems to be in a sense that those who are most familiar with your work prior to the book in Private Law is the chapter they'll be most familiar with, in the sense that this is the chapter in which the continuity thesis comes back in. Yeah? So the continuity thesis is, I'm going to mischaracterize it wrong. A version of the continuity thesis is to say that whatever reasons we have for the primary duties we have, when those duties are breached, those reasons don't disappear, they continue, and they are the very same reasons which justify the obligations to pay damages and outside of
pretty
law,
good, Rob.
to apologise,
extremely close.
So on.
Yeah.
Okay, a question about the concept. Why do we need wrongdoing then, if this is true? Why don't we just say, well, it's all just, because this goes back to my point at the start, you're being a reasons fundamentalist. Why don't we just say it's all just reasons all the way down, and say that all's happening is the way in which, the context in which you find yourself, the facts in which the reasons apply are sort of changing over time, just in the same way as, you know, what you have to do on a motorway is rather different from what you've got to do on a B road and this sort of thing. And okay, the facts have changed because, you know, you've run somebody over, but it's just the same old reasons all the way down the story. So why do we need wrongs at all on this view of the world?
Well, so in the way that some people want us to need wrongs, we don't need wrongs.
Yeah.
I mean, some people want us to need wrongs because they want us to do a lot more finger pointing than I want to do. So they say, well, it changes your normative position in the world that you're a wrongdoer. And I said, well, it doesn't, right? These were your reasons, and they haven't gone away just because you didn't conform to them. That's the most general statement of the proposition. And sometimes this really matters because sometimes the reasons are categorical reasons. That's to say, it's not up to you whether they remain or don't remain. You're stuck with them even when your goals change. So you can't, having not conformed to them, say, well, I was never interested in that anyway. Which you can do, by the way, with a lot of other things. You say, well, so I tried to learn the drums. I had no sense of rhythm, right? And now I'm giving up. Right? Those reasons are in my past. And I don't intend to resuscitate them with, you know, reparative drum playing tomorrow. Yeah. And that's fine because it's not a categorical reason.
Yeah.
And so, some reasons are just to be weighed up in the balance of considerations, but others are mandatory or peremptory. That's to say, they don't just get weighed, they also exclude other reasons that you're now not to count. And that matters too, because you can't then just go into a sort of fresh weighing process when you've got reasons that tell you not to count some of the things that you would otherwise mind. So now you've got these ever more special situations in which the reasons are categorical and the reasons are mandatory. And you know what categorical and mandatory reasons are? They're reasons of duty. And you know what it's called when you breach your duty? It's called wrongdoing. So now we've got all the features that explain why wrongdoing is of special importance. It's not of special importance because you're a wrongdoer and now everything's changed. It's of special importance because these are the kinds of reasons that were left behind when you didn't do what you were supposed to have done in the first place. They were categorical and they were mandatory, and you're kind of stuck with that. And now you better tell us what your next plan is, right? Because you still got that stuff hanging around, and changing your mind or deciding to count some other stuff, that's not enough. Because they're the kind of reasons where you weren't allowed to do that in the first place, and you're still not. Right? So that's how it works. And so it's not true that we don't need the notion of wrongdoing. We do need the notion of wrongdoing, but we need it as a sort of branding for what I'm interested in, which are the special force and tenacity of those reasons that are involved in all those cases that I discuss in 3 and 4 rather, in chapters 3 and 4, where the fact that something's left behind is still a big problem for you. Yeah, there's still somebody out there who you haven't finished with. Or something out there. So that's what. So I think that the difference between those who say what happened to wrongdoing and me is a slightly temperamental one, in the sense that I think wrongdoing matters and they think wrongdoing matters. I think wrongdoing matters because wrongdoing is a good name for a sort of failure to act in accordance with certain kinds of reasons where what's left behind is quite important. Whereas some people think it's a change Other than that, it's an independent kind of change when you're a wrongdoer. I think that Kant tended to think that it's sort of a poisoning of the soul view or something like that, and that made for all sorts of extra problems for him that I just don't see.
Yeah. I mean, I have considerable sympathy with this claim, but one of the claims you've got, which I have rather less sympathy with, is you quite a lot of the time, at least in the law of torts, you want to make loss, by which I think what you mean by loss is the consequential state of affairs of being worse off, something like that. And so central to the story, not necessarily central to what it is to be a wrong, but central to what it is to be a tort or justifiable as a tort, something like that. That even those torts which are actionable per se, we're making them actionable per se because they tend to give rise to losses, and so okay, we may not always require proof of it, but and that in a sense leads us into chapter. I haven't got my numbers right. 5, is it? Where we're talking, say it with flowers, because it's 4. Say it with flowers with 4.
Yeah, it's kind of about apologies and other ways of representing your.
Right, because in a sense for you, general damages then become a bit of a problem.
Yeah.
Because for somebody who says the loss is not really the centre of the story, general damages is fine. That's just
I'm not sure it's less of a problem for them. It's just a different problem.
But for you, because they're not reflecting some consequential loss. You have to have some sort of other move for them. Is that if that's not that's a correct characterisation? And the sense being that some cases you say that this is like a placebo, or to, as it were, make you feel better for having been wronged or something like that. And that's the goal of general damages,
or some general damages.
And that's the central theme I saw in 4.
Yes, so chapter 4 was difficult to write because I was very interested in a general moral problem that doesn't figure as much in the law about why we should make things right with people. Apologize, recant, confess. And the law tends to look ridiculous when it demands those kinds of things, because by the time you're litigating, it's a bit too late for that stuff.
Yeah.
Often, there are some exceptions, and sometimes I made fun of the exceptions, but sometimes I was serious about it. So I got onto general damages mainly in the aftermath of thinking about apologies. And I thought general damages are a problem for everybody, and not just for people who have my views. How do they make things right? How could they work? What's their magic? Because after all, it's common ground between their defenders and their opponents. That the sums involved are arbitrary, that they don't correspond to anything that could be summed, and that fights can be had about them mainly by what they represent. So people will say, is that all my wife's life was worth? To take the Wilbur Smith story again, a mere £10,000. Is that all she's worth to you? Just as they would say in the criminal courts, is 6 months imprisonment all my wife's life was worth? And these are interesting questions about meaning, the representational force of various kinds of quantifications. And I was kind of intrigued by all of that. And I was trying to explore the possibility, I may not have got very far with it, that there were two different forces at work in these sorts of situations. One is the continuing power of the continuity thesis, which is discussed in the previous chapter, which is all about losses that can be summed. But it has a great hold over us. And so we sort of think, can't we push it further? Can't we use the logic of the continuity thesis to repair the irreparable? Well, the question already shows that we can't. But if only we could. So there's that whole psychological force to see if we could get further with it. And at the same time, there are all these interesting problems about the way we speak to and address those we've wronged, which come up in the literature on conflict resolution after war and massacre and apartheid and so on. And there's other cluster of problems, which are about what you can do with symbols, including symbols of sort of self-abasement, not always flowers, but sometimes, making yourself small, in the face of somebody. And so these two things somehow are coming together in my way of thinking about general damages. We're trying to push the continuity thesis further. At the same time, we're trying to represent in law something that we seek in ordinary life through symbolic behavior. And it's not unnatural to think that when everything else in the law is done with money, you might find a way to try and do that with money as well. But then you immediately get into all sorts of problems about escalation and not being able to explain why you've given that sum and why it's less than Mick Jagger would have got if you'd run over his finger.
I'll give you an example. So the example I was thinking about yesterday, because of the gay cake case, is Constantine against Imperial Hotels. So what happens in Constantine against Imperial Hotels is we have a black cricketer called, I can't remember his first name, Constantine, goes along to Imperial Hotels on Russell Square, and he's got a booking for the night, and they turn him and his family away. And the reason they turn him away is because they got American white service personnel in the hotel at the same time. And it's a black guy, we don't want him. Right. And so the hotel is saying no. And it's not a claim for breach of contract. So if they've just got a breach of contract claim, you would have got nominal damages.
Yes.
And the reason for that is he just goes around the corner to another
hotel. In Russell Square.
So it's not a problem. So they just put him in another hotel owned by the same proprietors. But he doesn't sue for that. He sues for the breach of this duty, this common callings duty, that they're innkeepers and they're not allowed to turn people away.
Yes. And
he says, I'm just a person, you're allowed to turn me away. And the court says, yeah, that's right, we don't have to prove any loss. 5 guineas you've got to pay. And it's more than nominal damages, not 10 shillings or whatever. It's 5 guineas you have to pay. And the answer I would give to why you have to pay damages is because of the wrong. And that's it. I'm just stopped there. And so I'm not going to say placebo, or I don't care whether he's cheered up or delighted by being turned away, or has no consequences whatsoever, or nobody else has any consequences whatsoever. It's just he was wrong. He gets a sum of money because he was wrong.
Yeah. Well, all I can say is your view has more mysteries in it than mine.
Yeah.
I mean, I'm not sure how that all works, right? You might say, I take your view, and I spend our whole chapter trying to work out what all the other steps are that we would have to add to make sense of the proposition that he gets his 5 guineas just because he was wrong.
Yeah? Well, isn't it still the continuity thesis? We are where we are. We can't go back in time. What can we do? Well, the next best thing we've got is the sum of money. Well,
I'm glad you put so much faith in my other thesis.
Yeah, I do. Yeah.
That's great. That makes me feel better.
Right,
so, okay, if it's a continuity thesis case, then it's a continuity thesis case, and I warmly accept the suggestion. Right. If it's not, then we have to find out what's going on. So it could be either. I mean, there are problems about that, right?
Yeah.
So it's so take the kinds of cases that I do discuss a little bit, like Jarvis and Swan Tours and so on. They're a bit problematic. These cases about trying to compensate people for lost fun. Or even worse, sort of occasions, unrepeatable occasions that they missed, and things like this. Yeah, this is really hard because there are some continuity thesis elements, but there are some non-continuity thesis elements. So, well, we can give you some kind of fun. You know, you may have wanted this holiday, and it's too late for that because the famous sail past of the Royal Navy only happened. But we can give you another kind of holiday that's a bit like that, in which you don't see the Royal Navy go past, but you do see the red arrows fly overhead. So we're sort of trying to think about what would be the closest. That's continuity thesis stuff. And then other times we're just thinking to ourselves, well, we can't just let it go unremarked or unnoted in the way that we assess the damages. That that this could only happen once. That it was your wedding you missed, or So these things are in tension, and so sometimes, as I think I hinted at more than one point in chapter 4, the distinction between general and special damages doesn't exactly map onto the distinction that I'm drawing between the more apologetic and the more, the more continuity thesis. Inevitably, the legal distinction is a bit. I wouldn't say it's a mess. It's just a reflection of different competing instincts that are found all the time. And so I was actually very interested in these excellent writings about conflict resolution outside the law, partly because they were very interested in the meanings that these sorts of measures, including money measures, might have. They're more interested in meaning than lawyers usually are. You're able to find out things about Rwanda or about Aboriginal populations that you wouldn't usually find in the law reports. And it's quite revealing. It's quite interesting to see, for example, that sometimes the spontaneity feature is not the only feature that people crave. Sometimes they want the apology to be long and drawn out and at gunpoint, because that's a more effective message of some kind. So I'm not an expert on that kind of anthropological stuff, but I didn't think we should ignore it. And I really think that it does play a role in the law. Is sort of the meaning, significance of payment and the context in which the payment is made. So I was kind of interested in a slightly, sometimes sarcastic way in the apology that that was secured for one of the big rail track disasters much later, that came from a totally different corporation. It just happened to have been created after those disasters in order to take all the responsibilities, and somehow it was able to do something meaningful in respect of a totally different organisation's wrongdoing. I thought it was kind of a crazy case, but that it was crazy was not. You couldn't understand why it was crazy until you understood what might have been, what people might have been looking for. Had they only been able to get their hands on rail track, and they had all sorts of fantastical imaginings about what kind of thing rail track was, that remind one of Evans Pritchard and totems and taboos, and they create a picture that's not a corporation really. It's a sort of malign force, and they want to wrestle with it in sort of Indiana Jones way and show it defeated. So some of that's going on, isn't it? And tort law does some of that too. I think even in the case you're thinking of, it's doing a little tiny bit of that, wrestling with the forces of evil that where it was the hotel in Russell Square.
Well, look, I won't press you on whether you personally have to apologise for Codrington. So that'd be
a good question. The college has wrestled with that.
I think a little plaque probably good enough.
We've done our plaque.
Have
we finished?
But I think we've covered. I'm acting under instructions here, so my instructions were to stop after an hour. We've gone way over.
We've gone over, but we still have time.
So I think you've got a flavour of most spare outline of the book. I think we're going to open it up to the floor now to ask John some questions, so I get to shut up.
But thank you, Rob. That was really fun, really interesting.